Greetings and welcome to Troutman Pepper Locke's post-grant podcast series. My name is Andy Zappia and I'm joined today by my colleagues Bryan Smith and Nick Gallo. In this installment, we're going to take a look at the changing landscape of discretionary denial practice at the PTAB and how that's going to impact strategy for patent owners in particular, but it can impact strategy for petitioners as well. Just to set the table a little bit, at the PTO in February, the memo issued by former Director Vidal providing guidance on PTAB discretionary denial was withdrawn, and a new memo was issued last month. And this has created a lot of activity and changes in strategy when it comes to discretionary denial. But before we get into that, I think it'd be helpful to discuss what this discretionary denial issue is in PTAB practice and how we got to that guidance memo in 2022 that Director Vidal issued that has now been rescinded. So, Bryan, I was hoping maybe you could talk a little bit about what this discretionary denial practice is at the PTAB and some of the rules that developed around it.
Sure. Thanks, Andy. Section 314 allows the PTAB discretion as to whether to institute trials in inter partes review proceedings. And this initially became an issue with the NHK Spring case, which established that parallel proceedings could be used as a basis for that discretionary denial. For example, if a parallel district court case was set to come to a conclusion prior to the date of the final decision in the IPR proceeding, NHK Spring determined that that could be used as a basis for discretionary denial. And once that case was in place, the PTAB then issued guidance in the FinTIV decision that further fleshed out the circumstances under which the discretionary denial would be used for a parallel proceeding. And I'll quickly go through those FinTIV factors because those are going to actually become more important because, as we'll discuss later, the new memos that are coming out are resulting in a return to a more fulsome application of those factors in coming to denial decisions. The first factor that the PTAB considers is whether the court granted a stay or whether there's evidence to suggest that the court will grant a stay. So that might relate to actual decisions that have come down from that trial court. The second factor is the proximity of the court's scheduled trial date to the projected statutory termination of the IPR proceeding itself. And that's the PTAB's final written decision is due 1 year from the institution date. The third factor is the investment that the parties have made in the parallel proceeding before the district court. The fourth factor is the overlap between the issues that have raised in the petition and the issues that are pending before the district court. The fifth factor relates to whether it's the same parties involved in the district court proceeding as in the IPR petition. And finally, the sixth factor relates to other circumstances that may impact the PTAB's exercise of discretion. And one of those factors is the merits of the petition, which became very important under Vidal's prior guidance, but will become less important in just a sole factor, as we'll discuss a bit later.
Thanks, Bryan. And one thing just for clarification is that this almost always comes up in the context of IPR proceedings because the vast majority of petitions filed are IPRs, like 95+%. But this also technically applies in post-grant review as well.
Yeah, that's correct.
Yeah, but there just aren't very many of those, which I think we've discussed why in a prior podcast. And as far as the impact of FinTIV, a lot of petitions were getting denied on these factors, right? Over the course of time, and discretionary denial was an argument being made a lot. So let's talk a little bit about Director Vidal's 2022 guidance. How did that adjust FinTIV or add to FinTIV? You might as well pick up this one because you just talked through the FinTIV factors.
Sure. Yeah, as you mentioned, Andy, after the NHK and FinTIV decisions, there was a large uptick in the numbers of discretionary denials that were being issued by the PTAB, resulting from this issue of the parallel proceedings. So I think Director Vidal's guidance was One, to reduce the number of discretionary denials and provide some further clarity to both patent owners and petitioners, and also to reduce some of the issues related to forum selection. For example, if you were to choose a district court that was very quick, some of the rocket dockets that are known, you would be more likely to avoid a discretionary denial as the patent owner. So Director Vidal provided some guidance that was meant to take some of the discretion out of the discretionary denial. In particular, there were 3 categories where a little bit more certainty was provided. And those categories include when the petitioner provided a stipulation, often referred to as a sotera stipulation, that it would not pursue in district court the same invalidity grounds that were raised or could have been raised in the IPR petition. So under Director Vidal's guidance, filing of a sotera stipulation became determinative and could avoid discretionary denial. Second, Director Vidal found that parallel proceedings at the ITC would not impact discretionary denials based on the limited impact of the ITC's holding on validity. And third, Director Vidal provided a category of petitions that should avoid discretionary denial where the petition itself presents compelling evidence of unpatentability, which is inherently subjective standard, but gave some definitive statements as to how a petition would be decided when based on the strength of the merits itself.
Yeah, thanks for the summary. And I just from PTAB practice myself, I can say that the Vidal memo did provide certainty, right? Because you do this sotera stipulation, you would take discretionary denial off the table if you had the wording that the memo required, right? And same thing, if you had an advanced ITC proceeding, you wouldn't have to worry about discretionary denial because that didn't count anymore. The compelling merits, I don't know how much that changed things because that's a murky standard anyways, what's compelling merits. But certainly if you made an argument that, hey, my petition is really strong, so don't deny it, that was a basis under that guidance to avoid discretionary denial. So, we've been operating under this guidance for a while. Then we come to a change to it, right? And Nick, maybe talk a little bit about the explanation that came out from the current Chief Administrative Patent Judge about why it was withdrawn.
Yeah, sure, Andy. I don't know if you'll find this reasoning persuasive, but basically the Chief Administrative Patent Judge said, here we are 3 years later, and Vidal's guidance was meant to be interim, but it was never codified. And basically on that basis, he decided to rescind the memo and restore policy to the prior guidance, which of course is the precedential FinTIB ruling.
Yeah, and I can mention there was a proposed rule to a regulation on this whole FinTIB standard, but it was never adopted. It did track FinTIB pretty closely, but it didn't advance. So now that we're back on FinTIB standard, in part, because we'll talk about the next thing that happened, but now that we're kind of back on FinTIB, does that mean that the standards that were in the memo of 2022 memo don't matter anymore?
No, not exactly. Those are still relevant. So the Chief Administrative Patent Judge provided more guidance on those factors that were in Vidal's memo. So relating to the ITC and the sotera stipulations and the compelling merits, basically the judge said that those are still relevant factors, but not as positive as Vidal set forth in her memo. So if you think about the ITC, basically his view is, well, it's practically difficult to assert patent claims that the ITC has determined are invalid in a remedial order, even though the ITC is not authorized to invalidate a patent.
Yeah.
So that is now a relevant factor where it wasn't for several years under the Vidal memo. I can talk about the sotera stipulations too. So those are still relevant, just not dispositive on their own. So Judge Bolick said that they are highly relevant to the discretionary denial analysis. Same thing with compelling merits, still part of a balanced assessment. So we think that sotera stipulations still have their place and should be used when appropriate.
So it seems to me, just to look at a high level, is that they're just handing a lot of discretion back to the panel on discretionary denial, right? because the memo set out certain rules. If you did X or Y, you'd have to worry about discretionary denial. Now they're saying, well, you can still do the stipulation, but it's not dispositive. ITC can be a basis for denial. You can make an argument based on it. The merits issue has always been there under FinTIV and the guidance. Am I reading this right? That basically the panels on individual proceedings they're kind of back to where they can sort of make the call on it.
Yeah, I think that's right. There's just less predictability, more discretion. And I think that's by design. I think Judge Balick is concerned about workload of the PTAB and having more discretion to deny IPRs allows the PTAB judges to more appropriately balance that workload.
Yeah, because if you looked at, for example, in the 2022 Vidal memo, time to trial seemed like the biggest important thing, right? It really emphasized that. So is that a little different now? Like that was sort of when I used to read it, if you were still had to worry about discretionary denial, like, for example, you didn't do a Sotera stipulation. A lot of times you had to hang your hat on time to trial if you want to have a safe position on discretionary denial.
Yeah, I think that may be the most important FinTIV factor. Of course, it gives rise to all the prior issues on, relating to the rocket dockets, but.
So maybe it drives more cases into those fast venues because you have a better chance of getting petitions denied.
Yeah, I think that's right. ITC, as we know, is very fast as well. I'm not sure if it drives cases there, but, more IPRs with parallel ITC actions will likely be denied under the new discretion rules.
Yeah, and then I view like the ITC change, kind of the PTO going back to this efficiency thought, because the ITC can't invalidate. They can't cancel patents, right, or claims.
Right.
But the efficiency, it seems like they're emphasizing the whole efficiency thing because they're saying, look, it doesn't make sense for the ITC to go through and find like an exclusion order and patents that are found invalid elsewhere, right? They're basically saying it's just double work. It doesn't really matter whether the ITC can actually cancel a claim.
Yeah, I think that's right. The current chief judge is very focused on practicality in that regard.
Yeah. Well, Bryan, we were just starting to get our heads around this whole world again. And then another thing came out. So Acting Director Stewart then issued a memo. Tell us about this from the Acting Director. What does this new memo say? How does it change things?
The new memo from Director Stewart created a bifurcated process to deal with the increased discretionary denials that are likely to come out of these change in policy. And basically what it sets up is a mechanism for the PTAB to look at discretionary denial issues before getting into the merits of the case. So based on the new memo, discretionary denial issues will be first reviewed by the director herself and at least 3 PTAB judges to determine if they warrant discretionary denial. So the discretionary denial decision will be determined at the outset as opposed to jumping into the merits. It'll be interesting to see how much a merits-based discussion comes into play given its listing among the FinTIV factors. But certainly this new memo sets out a discretionary denial analysis that will occur before any actual decision on institution.
And it goes to somebody different, right? It goes to the director and a specific group of judges.
That's correct. So it'll be a very large workload increase for the director to deal with all of these discretionary denial issues personally based on the number of IPRs that are filed each year.
How about the mechanics of this? There's some new mechanics in there, right? Timing and page word limits and stuff.
Yes, exactly. The memo set up basically a briefing schedule to allow this issue to be dealt with in the forefront. And patent owners seeking discretionary denial can file a brief of up to 14,000 words explaining why discretionary denial is appropriate. And the timing for that is within 2 months of the filing date that's accorded to the petition. And the petitioners then get a opportunity to respond in an opposition brief of up to 5,600 words that's due 1 month later. According to the memo, the rest of the briefing will remain unchanged, but it remains to see how this initial briefing on discretionary denial will impact the initial patent owner preliminary response, which would be due at the same time as the petitioner's opposition briefing.
Gotcha. 14,000 words. That's the same as the preliminary response word limit, right?
That's correct.
You can put a lot of arguments in there, right? For discretionary denial if you have that many words.
Yeah, and it's assumed that these briefings would follow the definitive factors, at least initially, until some clear guidance is developed through cases handled by the board or perhaps rejected by the director under discretionary denial.
Did the acting director talk about why the bifurcated approach at all?
There's some indication from the actual title of the memo that it's called Interim Processes for PTAB Workload Management. So reading behind that, it provides some significant insight that this is directed to allowing discretionary denial in more cases and at an earlier outset to preserve PTAB resources. Question whether it'll do that with the initial workload that's required to evaluate these discretionary denial briefings, but it should at least allow for easy cases on discretionary denial to be dealt with in an earlier fashion before the PTAB judges have to dive into the merits of the case.
Yeah, because I guess the way it works is this discretionary denial briefing would be done at the same time that the preliminary response would be filed by the patent owner, right?
The briefing should actually be finalized before on the date that the POPR is due.
Right. So theoretically, this panel that looks at discretionary denial, they're going to be doing that before the merits panel digs in on the merits of the petition, because they could issue their decision. And if they deny institution based on the discretionary denial factor, then the merits panel doesn't have to do the work of digging into the merits. That's presumably how it's going to work, right?
Yeah, that's correct. Unfortunately, it doesn't ease the burden on the parties who now have to brief this issue, in addition to for patent owners prepare their preliminary response, because they won't have a determination on discretionary denial at that stage.
That's completely right. Do you think, Bryan, that some of the stuff that's going on at the federal government, some of the layoffs and downsizings and budget cutting was a factor in this new guidance from Acting Director Stewart?
I think that's a reasonable conclusion. The PTAB, specifically Judge Bullock, has acknowledged that PTAB staff reduction is expected, which would reduce the PTAB judge headcount potentially significantly. So in view of the statutory requirements that are placed on the PTAB in order to finalize these proceedings within the time frame laid out in the statute, the reduced workforce could be a significant issue. And certainly it seems that these increasing the options for eliminating cases based on discretionary denial would help the PTAB to deal with that workload issue.
Right. So from a petitioner perspective, right, is there any way for a petitioner to feel secure now that they're in a good position on discretionary denial, or is it like a lot of uncertainty on that now?
It's very uncertain at this time. There's just, these memos have really eliminated some very surefire ways that petitioner could go about avoiding discretionary denial. And they've also introduced some additional factors into the analysis that it's unclear exactly how those are going to play out. For example, the memos mention diving into issues of whether expert testimony is required, and it's unclear exactly how that will go into the calculation of whether a discretionary denial should be issued. So we'll see quickly as these discretionary denial decisions start to come out and what factors they have looked at primarily. But for right now, there is clearly a lot of uncertainty as to how these factors will be analyzed. And it's unclear whether there's any way for petitioner to know whether they're likely to get denied based on workload issues. I mean, certainly they can monitor the number of IPRs filed in a given year, but it's hard to come to any conclusion based on that as to whether the PTAB is overloaded with work and might be inclined to issue a discretionary denial on that basis.
Right. So, Nick, is there any practical guidance you could give to our listeners, whether they're on the petitioner side or the patent owner side?
Yeah, I think there's some takeaways here. For patent owners, district courts with faster dockets are more attractive again, as they were previously. The ITC, as we stated before, may see increasing popularity. Time to determinations for the ITC tend to be around 16 to 18 months, which is pretty quick and faster than most district courts. So an IPR petitioner would have to file relatively quickly to have any chance of asserting that the IPR will conclude before a parallel ITC action. For petitioners, filing as early as possible remains the best strategy to avoid discretionary denial. And to be able to do that, preparation is key. So petitioners want to think about if a dispute is percolating, let's identify the prior art we might use to validity grounds. Let's get an expert on board. And try to do all that before the complaint is served to accelerate the petition filing. Soteris stipulations still remain the best tool as far as we can tell from the most recent guidance to avoid discretionary denial. As long as the estoppel is tolerable attached to an institution as compared to a final written decision, those should still be useful to avoid discretionary denial. So, in particular, if the merits are strong and the likelihood of institution on all claims is high, but other definitive factors weigh in favor of denial, the soteris stipulation should be strongly considered. Basically, I would say the bottom line is we expect less predictability, more discretionary denials, all of which should benefit patent owners.
Yeah, and I'll just give an example from my own practice. This could be beneficial to any listeners who are in a similar circumstance. We had some IPRs where we already put in our preliminary response, but because of some of these changes, we now had a discretionary denial argument that we didn't have before. So we went to the board and said, hey, can we put in a supplemental submission on discretionary denial? They very promptly said yes. So if any of our listeners are in that circumstance where they're a patent owner counsel and they've already put in their preliminary response, but they didn't make this argument because of the old rules, the board, at least in my proceedings, said, fine, yeah, go ahead and put in the supplemental submission.
Think that indicates an eagerness to dispose of the IPR?
I think my client would hope yes, but
Right.
We'll see what the board wants to do. Well, look, guys, this was great. It's very interesting. And it's a changing landscape. So maybe we'll revisit this next year and see how it panned out. And we'll look at some of the stats. But I think it's safe to assume we are going to see more discretionary denials. So thanks, Nick. Thanks, Bryan. Troutman Pepper Locke's intellectual property team will continue helping its clients develop and implement global protection and commercialization strategies for intellectual property. For more information on how we can help you, please visit our website, troutman.com. You can also subscribe and listen to this and other podcasts and our series on post-grant procedures, including on Apple, Google, Spotify. Thank you very much, and we'll see what happens.
Copyright Troutman Pepper Locke, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper Locke. If you have any questions, please contact us at troutman.com.